My name is Tia Grasso. I am OCEA's Associate General Counsel. And in my role, I support the reps, I support campaigns, and I support negotiations. Today's training is really going to focus on deepening your understanding of our MOU. For those of you who have been with OCEA, who've been with the county for a while, this might be frustrating because you're like, I know all this stuff. This is just a refresher for me. For those of you who are newer, who don't have as much experience with the MOU, you may say, wow, that was a lot. But I'm trying to hit a sweet spot so that we all have kind of a working understanding of what the MOU is, what the MOU isn't, and the role that you can play either as a union action team member or as a steward. So in your day-to-day lives, you can rent an apartment, you can lease a car, you can enter into a new cell phone plan, you join a gym, and you're going to be issued a contract. And the hope is that you read it. In the employment setting, it's no different. We have employment contracts that we refer to as Memorandums of Understanding. It surprises me how much time people don't spend reviewing this very important tool that really dictates a lot of aspects of their waking lives, right? It moves people to do things that they wouldn't otherwise do, and that's the nature of a contract. Contracts take two people, bring them together and say, I'm willing to do this, you're willing to do that, and we agree to do this for a certain amount of time. So with your MOUs, keep that in mind, that the action, the purpose of your MOU is to really understand this is what the employer has said they will do, and this is what we've agreed to do in exchange. The learning objectives for today's training are going over what is an MOU. And this is going to be pretty broad, pretty high level, but we'll get down into the weeds as far as we can. We want to understand the legal authority for the enforcement of the MOU, because they're not just pieces of paper. They actually have more than a bark, they've got a bite. So if there's something that goes wrong with the application or the administration of the MOU, we have options as a union to ensure that our interests, our bargained for terms and conditions are met. We want to recognize the general provisions of an MOU. As I looked through the screen, I was kind of glancing at different roles. Sometimes people put their titles in their names. You all have a role that you play in the county. For most of you, that's not contract administration. So there isn't this expectation that you be expert contract administrators. But what we do want to encourage you to do is get familiar with the parts of the MOU that are most frequently reviewed, that are most frequently triggered, and in our work, most frequently misunderstood. Okay. We want to talk about your role as an administrator of the MOU and where that line is. We don't want you to take on the burden of administrating the contract. You're social workers, right? You're officers, you have these other roles, but we want to make sure that we are all positioned to be as helpful as we can as a union and that we're all rowing in the same direction when it comes to the administration of the MOU. Sometimes things go sideways. Sometimes there's a misunderstanding. Sometimes language is vague. Sometimes somebody who is administering the contract doesn't understand what the original terms were or what the original intent was. And that means we have to file a grievance. So we will talk briefly about what grievances are and the circumstances under which we would file a grievance. Like grievances, when we don't get relief at the local level, sometimes we have to take it to PERB, which is the Public Employment Relations Board, which is the agency that oversees MOUs here in California. Okay. If there's an issue with the administration of an MOU, we can take it to them. And then sometimes we can get relief from that agency as well. Right? So what is an MOU? In the public sector, a Memorandum of Understanding is a binding contract between the employer and the exclusive representative, your union, of a recognized bargaining unit covering the terms and conditions of employment for the bargaining unit employees. Now, that terms and conditions of employment is important because that really is defined by the scope of our representation as your exclusive representative. Again, I want to reinforce this. It's important because our contract can't cover all things. Our contract is limited to those things that we have the legal authority, right, to provide representation over. And that's, broadly defined as the scope of representation. So one of the things that when I have conversations with people, one-on-one or in groups, I encourage people to remember that there are going to be times where something comes to us as a union, times when people said, can we roll this into our MOU? And unfortunately, the answer is no, not because we're lazy, not because we don't like to take on challenging things, but because that issue is something that falls outside of the scope of representation. And I'll use one example of that, which is workers' compensation. Oftentimes, people will come to us and say, I've got a workers' comp issue. Unfortunately, workers' comp falls outside of the scope of representation, so it's not something that we typically negotiate over. And with greater frequency, you're going to see employers removing references to workers' compensation from the MOU because it isn't something that we're negotiating. So in 1968, and going over where this comes from, where our authority to enter into these contracts originates. Back in 1968, the California legislature passed the Myers-Milius-Brown Act, what we refer to as the MMBA. And if you haven't heard that term before, now you're going to hear it because it's something that we reference frequently because it is the body of law, it's California government code that really lays out the perimeter, the scope of our authority as the exclusive representative to roll things into a contract through the meet and confer and negotiations process. The MMBA requires government employers in California to meet and confer in good faith with labor unions and representatives of recognized employee organizations on the following issues. Again, ding, I want to put a little asterisk here. The issues that I'm going to go over are the scope of representation, and these include wages, hours, and other terms and conditions of employment. That last one is a big one. It's a catch-all. So when we're looking at issues and you're like, well, is this within the scope of employment? I mean, is this a term and condition of employment? Is this within the scope? We always try to stretch that as far as possible to scoop up as many things as possible into that catch-all element of the government code. Are there items on which an employer is not required to meet and confer? I.e., are there things that fall outside of the scope of representation? And of course they are, okay? Examples might be benefits for retirees. Well, once somebody retires from county employment, they're no longer within our bargaining unit. So when an issue comes up that affects the retirees but has no effect on current actives, it's something that falls outside of the scope of representation. Promotional procedures, that is essentially a management right. They can dictate outside of a civil service system, they can dictate what the promotional procedures will be. That's something that falls outside of the scope of representation, which can be frustrating. The right of a union to file grievances. Well, the right for us to file a grievance comes from the government code, comes from MMBA. So that's something that we don't have to negotiate over, right? Generally, all other matters, and I'm going to list some, but these are not exhaustive, involving wages, hours, safety, layoffs, services, training, require some degree of meet and confer because they fall within the scope of representation, or we have made the argument that it's reasonably related to the scope of representation that the employer needs to sit down with us and meet and confer, i.e. negotiate over either the decision or the impacts of the decision on a go-forward basis. So when we have issues that fall within the scope of representation, we enter into negotiations. Employee unions and the employer are required to negotiate in good faith on items within the scope of representation. And that good faith part is so important. If there's something that falls within the scope of representation, let's use wages as an example, and the employer says, these are your wages, take them or leave them. Did they negotiate in good faith? And the answer is no. They have an obligation to come to us with an open mind, just as we have an obligation to come to them, come to the table with an open mind and negotiate in good faith through that process. If we get a sense that they're showing up and the deal's already done, they're not meeting their expectation or their obligation under the law. If an agreement is reached, the parties prepare a tentative agreement and memorialize the details and the terms of that agreement in a TA. Those of you who have been with the county for a long time recognize this process, right? We do these in smaller scope, on smaller issues through side letters. We do these through resolutions through the grievance process. But if we reach an agreement on something that falls within the scope of representation, we memorialize it. That way, everybody's on the same page. As a lawyer, I love everybody being on the same page. I love us all understanding what the expectations are. I love us all understanding the purpose for it so that we can all track in the same direction, right? So that's what these tentative agreements give us. They give us a roadmap for what we can all mutually, both parties, expect going forward. Once ratified by the union membership by vote, the agreement must then be adopted by the governing body of the municipality for final binding approval and adoption, okay? In other words, an MOU is born. Once we have an MOU, As stewards and as union action team members, I think it behooves us all to be familiar with the general provisions. I know there's, looking at the number of people on this call, some of you have tons of experience in other agencies. And when you came to the county, you were like, wow, this is a really long MOU, right? This is a lot of pages, a lot of articles. Well, it's what we refer to as a mature MOU because it's been around a while. We've done this dance enough times where we recognized we need an article, we need a provision that addresses this concern. Those of you who have worked in other municipalities may have had an MOU that was, 15, 20 pages long. We call those slightly immature contracts because there hasn't been enough time for them to truly be built out and developed. But in a mature MOU, you can expect to see the provisions listed here. And these include things like work week, right? A clear definition, there's gonna be a theme here. All of these are geared towards making sure everybody's on the same page when it comes to the expectation. So a work week is gonna be defined. I've seen MOUs that define a work week as, Monday through Friday. I've seen others that say the work week begins at 12:01 on a Friday AM and ends, on the following Thursday at 11:59. They get that specific. Okay, but there's a reason for it. Something came up. There was some confusion that the language needed to be that clear to make sure everybody was on the same page. Salaries and increases are typically listed in the MOU. When we negotiate contracts, the negotiations process, there's typically going to be pay raises of some sort. Those are memorialized there so that people know what that pay raise was and when the effective date of that pay raise will be. Everybody's on the same page. Premium pays. People do certain things that require them to be on call, to use bilingual, to use a second language. When they are eligible for a premium pay, we want to make sure, what is that premium pay? What is the rate? How is eligibility determined? And in what circumstances, can it be limited or taken away? Again, same page. Overtime. Those working in the public sector recognize that there's a need often for overtime work. We as the union want to make sure that that is controlled. We want to make sure that people are not taken advantage of because again, the employer in a public municipality typically has a need to provide some level of service, either statutorily or through some sort of contract. We want to make sure their obligation to their contracts, their obligation to the law, doesn't require that you are all overrun with overtime, as a result. So overtime is absolutely typically defined and is one of the most often referred to sections in an MOU as a result, because of the impact that it has on the individual. Probation. Probation is typically one of the longest and most detailed sections of an MOU for a very important reason in the public sector. Because once you pass probation as a public employee, you have job rights, right? You actually have an ownership interest in your position. Because of that, they want to make sure if you are, in the probationary process, which for all intents and purposes means you are still in the selection process, that you know exactly what you have to do in order to cross the finish line and get off probation. So those of you who reviewed that section before recognize, wow, that's a lot of detail. The reason is there because if they try to let somebody go at, in the 11th hour, in the 11th month, that person has had a lot of notice about what was expected of them and what their rights are or aren't. Performance evaluations. You all don't come to work just for a high five. Oftentimes you want meaningful feedback on the job that you're doing. So oftentimes MOUs will include references to performance evaluations, what right looks like, what's acceptable, and what would be a violation of the employee's interests if, for instance, a performance evaluation isn't supported by fact or isn't done in a timely manner. Sick leave and vacation. I'll take those two together, but then I'm going to separate them out. Again, I'll let you know, these are two of the most frequently visited sections of our MOUs because one, people get sick and oftentimes have a need to leave work. And most of us are dedicated to our jobs and we don't like to leave our employer with a sense that we are shirking our responsibilities. So we want to make sure we are right where we need to be with regard to our use of sick leave. Oftentimes sick leave, at least a portion of it, is statutory. So there are going to be portions of the sick leave provisions in your MOU, which typically we avoid adding statute because we don't want this to be a legal document, like a legal treatise, a legal book, case law book, are typically not in the MOU. But when it comes to sick leave, because it's a mixed bag of both sick leave provided by the state and sick leave provided by the employer, that we want to make sure employees understand the difference between the two and the full extent of what they have a right to use. Reason being, when you're using sick leave for a particular purpose, depending on the source of the sick leave provision, it's protected. And we want to reinforce people's right to use their sick leave without fear of any sort of retaliation from the employer. Vacation is not something that's provided by the state. Vacation is something that has been negotiated. But vacation, just like sick leave, is something that we encourage our members to use. So we want to make sure that people understand their accrual rate, the process through which they need to request, time off, and the circumstances under which that request for or approved request for vacation can be canceled, because we know it matters to you as employees that you need to get your time off and get your breaks. We've negotiated it and you deserve it. All right. Healthcare benefits. Along with sick leave, which is taking the time to care for yourself or others, healthcare benefits are typically included in the MOU so that you have a full understanding of the full host of healthcare benefits that have been negotiated for you on your behalf. Leave provisions, in addition to sick leave and vacation, include things like bereavement leave, because life happens and we lose our loved ones and we need the time away to either mourn or attend funerals or to make arrangements for those funerals. People often find themselves in a position where they need support, they need help, and they need guidance. We prefer to see the bereavement leave provisions clearly laid out so that people aren't having to wrestle with, well, how do I get time off when I'm already in a really difficult spot? And for us, it's really important that it's in there to make that process as easy as it can be for you during a really difficult time. Disciplinary appeal process. So discipline happens, right? Sometimes it can't be avoided, but we want to make sure that our members understand, and we want to make sure that the county understands or the employer understands that you may discipline, but we have appeal rights. Those appeal rights are generally tied directly to your ownership interest rights in your job as public employees. They, the employer, cannot take away anything from you without notice and an opportunity to be heard. So while written reprimands hurt the soul and frankly, frustrate, when we get into things like suspensions and demotions and reductions and potentially terminations, when we're in that space, it's a potential takeaway. And we want to make sure that when somebody's appealing a proposed discipline, that all of the steps, their rights to be noticed and heard, are followed, because that's a right that they have under the law. Grievances. Grievances are different than appeals. I appreciate the county's MOU because it breaks them out. Sometimes I see them meshed together in other municipalities. Grievances are used when some aspect, some portion of the MOU has not been applied appropriately, or has been misapplied, or has not been applied at all. And we grieve the misapplication or the misinterpretation of the provision of the MOU. Right. So the grievance provisions should be, separate and apart, and it'll take you through the steps of that process. So if ever you find yourself talking to a coworker and they say, I don't think the county's following the MOU when it comes to, this provision of the MOU, have a conversation with them about grievances, but then visit that section, that article in the MOU to get familiar with, the steps of that process. Of course, you'll have OCEA reps, at your side and kind of as a tip of the spear along the way. Layoff procedures. So public employers have a right to lay people off. That's a management right. And it's tied to essentially, level of services. Even though they have that right, they still have an obligation to meet and confer with us over the application of that right, over the impacts of the decision to lay people off, which is why you see the layoff procedures in the MOU. So if ever, and I don't suspect that anytime soon because of vacancy rates and challenges with retention and recruitment, if ever we find ourselves in a position where layoffs are being discussed, that is a section of the MOU that you want to familiarize yourself with, because it lays out that procedure from soup to nuts. Two other sections or articles of the MOU, which I find, important to draw your attention to, are management rights and OCEA rights, and this balancing that's going into the rights of both parties to this contract. They differ from employer to employer, but it lays out kind of the line where the county or the employer's ability to assert their management right picks up and where OCEA's rights drop off. Okay, so take those two articles and read them when you get a chance. So generally, there are provisions that are not going to be included in the MOU. The list that we just went through on the previous slide is not exhaustive, but it kind of gives you an idea of the things that you can reasonably expect. And I did it for a reason, so that you've now got a little trigger. Next time one of those types of issues may come up, as a union action team member, as a steward, you can say, I think there's an MOU provision that touches on that. Let me go see if I can find it and review it. Sometimes things will come up and you'll be like, I wonder if there's an MOU provision on that. Well, let me save your time now by going over certain things that you should not expect to see in MOUs. Number one, federal and state laws. Harassment, discrimination, retaliation provisions, those are not things that you will typically see in an MOU. And those will live in policy outside of the MOU or a general order, depending on the employer. Work locations, you typically won't see a reference to work locations in the MOU. Service levels. As a public entity, there's an obligation to provide a level of service, given the function, at a certain rate. You will not see service levels typically negotiated in the MOU. Likewise, staffing levels. Staffing levels are kind of a twin sister of service levels, in that in order to meet your service levels, you have to have the requisite staffing levels. And typically, you're not going to see those in MOU. Reason being, and I ask these questions at the bottom of these slides, why are these items excluded? Because they're not negotiated. The employer and OCEA don't negotiate over these things because this is the management's purview. All right. And we want to make sure to the best of our ability, we don't muddy the waters by including these things in the MOU, because it can be frustrating, right? Because it's there. It seems like something that we can discuss. It seems like something we can grieve, but ultimately a grievance would be denied because ultimately it's a management right. Right. So as we look forward into the 2023 negotiations, know that the county has a team and OCEA has a team, that we're looking at the language in the MOU to make sure that things that should not be in the MOU, because they create confusion, because they give people a false sense of this is something that we can negotiate over, we're looking at those items and pulling them out where appropriate. Likewise, we're pushing things back in as needed. Okay. All right, so MOU administration, your role as a steward or as a union action team member. One of the first questions that I always ask internally and externally when someone comes to me with an issue, and it can be a city, it can be the county, it can be any public entity, what does the MOU say, right? Don't forget about the MOU. A lot of the answers to a lot of questions, a lot of clarity for a lot of confusion lives right there in the MOU, right? So when a member has an issue that falls within the scope of representation, which is the next thing that I want you as a steward and you as a union action team member, or you as an individual, to ask yourself as we do this kind of critical decision-making process, as we walk our way through it, is, does this fall within the scope of representation? Does it involve wages? Does it involve your hours, or does it involve other terms and conditions of employment? Now, that last one, you can make the argument that almost anything can be scooped up, and some arguments are better than others, but make sure that you can at least make that argument before you kind of fall down the rabbit hole into something that ultimately falls outside the scope of representation. So once you've made that determination, right, that this is something that falls within the scope of representation, circle back to that MOU. Right? Look through the table of contents if you're not familiar with it. If you've got a digital version, do a word find, and look to see if there is a provision that touches upon, or provisions that touch upon, the question that's being asked or the concern that's been raised. Right? If in that process, the plain language of the MOU is vague, ask your OCEA labor representative about the historical interpretation, past practice, or the original intent. We keep copious notes, very detailed notes of all of our negotiations for this express purpose. That sometimes, even though everybody's trying their best to develop language that captures, nearly all circumstances, and then that is clear and reasonably understood by everybody who is party to the contract, employers and members, sometimes it's vague, or sometimes there's a change in circumstance where the language doesn't quite, hold true the way it originally did. When that happens, don't get frustrated, because it does happen. But OCEA will work with HR to come up with a mutual understanding of, okay, what is the intent? What is the current understanding? And how is this going to be applied going forward? Okay. Side note, when these things come up, we keep a note of them. We call them our parking lot, right? So that when we enter negotiations and we have this opportunity to clean up the language of the MOU, we make sure we pull forward all of these issues that we've experienced during the time of the previous contract, right? Once you seek and receive clarification, you can then turn and advise your coworkers accordingly. I say this with a great deal of caution. I want you to make sure that you've got the right answer from the right source before you broadcast. Because one of the things that can be frustrating for folks is miscommunication, misinformation. We want to make sure we're all on the same page, rowing in the same direction, relying on the same source of authority. So that way we're all kind of showing up to the table, shoulder to shoulder as a unified front. So grievances. So oftentimes we talked about if there's ability to resolve any sorts of discrepancies or disagreements over what a language, what language says or what a provision was intended to do or how it's been applied. We hope that those can be resolved informally. And generally, that's the best practice because we believe it's the best use of everybody's time and resource. But sometimes that's not possible, and a grievance does need to be filed. Generally, a grievance may be filed if a management interpretation or application of the provisions of the MOU adversely affects any of the things within the scope of representation, wages, hours, and terms and conditions of employment. Okay. And I say this to make sure that we've got the right elements for the grievance before we begin. Sometimes people are like, I know this is grievable. And I'm like, let's break it down. And you're like, was there an adverse outcome? Was there an adverse impact? I'm like, well, no. And I'm like, well, let's look for all of the elements of this, of the need to file a grievance at the first floor before we get to the penthouse and realize we don't have the facts that we need to move forward. If you are interested in filing a grievance and you'll be working with an OCE, generally working with an OCEA rep on one of these, you need to identify a grievant. Under the county's MOUs, a named grievant needs to be provided. We can't do these anonymously, and we can't do them on behalf of OCEA on behalf of, fill in the blank regarding the staff. So we need folks to come forward. So I say grievant or grievance. We need to be able to line out the provisions of the MOU, the particular articles or sections of the MOU that have been misapplied or misinterpreted. And that's very important. If we can't really get our hands around what the issue is, it doesn't put the county in a position to have the conversation with us that they need to have. Okay. And lastly, you have to have a reasonable and effective remedy in mind. Sometimes there's an issue that comes up that, yes, it was a misapplication or a misinterpretation of the MOU. And yes, there was an adverse impact. And yes, we've got the grievance needed, but there's no remedy. So in my office, anybody who's been here knows I've got these steps written on the board to remind myself that before we run to a fight, that there's a reasonable and effective remedy waiting for us at the table. All right. Well, we bring it to the table, but make sure that it's there and available to be considered by the county. OCEA will file a grievance timely. These are time bound. So if there's an issue with misapplication or the misinterpretation of an MOU provision, please bring it forward timely. If you wait too long, the county is in a position to deny the grievance outright because it's outside of the time limits. So if you've got an issue, it's better to raise it sooner than later so that we have an opportunity to take action essentially before the statute of limitations runs out. Thereafter, OCEA will follow the steps of the grievance process set forth in the MOU. I don't line them out here because depending on the issues, this can go in several different directions, but generally speaking, we'll start at step 1, step 2, step 3, and beyond, okay? So how can you assist as a steward and a union action team member in the grievance? Well, first of all, you guys are subject matter experts. Right? Depending on the agency or the department or the classification that's being affected by the grievance, we need subject matter experts to fill in the blanks. We know, how to move this forward. We know the pieces of the puzzle, but we need you guys to color in the pieces of the puzzle for us with details, with facts, with past practice, with history, with intent, with impacts. Okay. So there'll be times where OCEA reps, will link arms with you and say, we need information. Right? That's a critical role that you play as a steward or as a union action team member. Another way that you can assist is just being on alert. If you hear something like, God, that doesn't sound right, or this person sounds like they're being harmed, don't be afraid to say the G word. Ask the question. Is this something that we can grieve? Let us all walk through that analysis together timely, right? But you as a steward are right there, your boots on the ground, your eyes in the field. You can say, I think this might be something that we can raise to OCEA to see if it's either been grieved and we have an outcome, or it's something that we can help with. Sometimes in grievances, there'll be a need to provide statements, right? Attestations, fact gathering. When that happens, you are all the audience that will turn to and say, who amongst you has information regarding this concern? And our hope is that you guys, because of your awareness and your intimate involvement with the worksite, can give us the information that we need to push a grievance through to success. Right? I'm sure we'll get additional questions on this in the end, so I am going to slide forward to our second to last slide, which looks at the Public Employment Relations Board. So like I said, if we don't get things resolved informally, which is ideal, all of our time is best spent resolving things at the lowest level, which is why there's language to that effect in the MOU. If the grievance process proves to be futile, or we don't get an outcome that seems to make reasonable factual sense, we do have the option of going to PERB. PERB, again, is the Public Employment Relations Board, and it is the state agency responsible for enforcing the collective bargaining laws. One example of those is the MMBA, covering public sector employees. If an employer engages in an unfair practice, such as a failure to meet and confer over an issue, right? So something fell within the scope of representation and they were like, meh, we're just going to unilaterally do this. We can go to PERB and say they failed to meet their obligation under the MMBA. All right. If there's a provision in the MOU, and I'll use an example of pay increases. If we negotiate, wage increases 2% and that are effective the first pay period that includes July 1, and nothing happens, and our requests, our attempts to resolve it informally go unanswered, we can go to PERB for enforcement. Okay, so if it violates the provisions of the MOU in the absence of an applicable local rule, and the county will have local rules, other municipalities have local rules, employees or their representatives may file an unfair practice charge, and the acronym for that is UPC, so you may hear that from time to time, with PERB. PERB will take it upon themselves to investigate the UPC, the unfair practice charge, by doing fact gathering of their own. They'll reach out to the complaining party, they'll reach out to the employer and say, give us all of the information on the complaint that we've received and this concern that we've received, and we're going to make a determination. If what they've heard, tips in favor of, this sounds like something that's harming the employee, they will issue a complaint against the employer, and the employer will have to answer to that. I lay this out there just so you understand and appreciate that, again, our MOUs aren't just there as window dressing. They're not just nice to haves. They don't just have a bark, they have a bite. And we do have the ability to enforce them. Okay, just like any, cell phone company or gym, when you try to, back out of your end of the agreement, they have the ability to enforce it, as do we. Okay. So, conclusion. In short, the MOU is the contract that binds the employer and the employees. The contract covers wages, hours, and terms and other conditions of employment. And I'll say it again, the scope of representation, right? When you have an issue that comes up, please ask yourself that question. Is this within the scope of representation? If it isn't within the scope of representation, you're not just done. You still have to think about, okay, what is my recourse? What are my options to find a remedy for whatever the issue is outside of the scope of representation? Still reach out to OCEA. We may be in a position to direct you towards that resource, even if the resource, leads you right to HR. But just because it doesn't fall within the scope of representation means it's not something that should be addressed, and it's not something that, there may be a reasonable remedy to fix it. Know where to find the MOU. They're always online here at OCEA, but know where to find it. Have it at the ready, right? That's the most important thing. And then next, be familiar with the most frequently referenced provisions of the MOU. The articles that I've listed on that previous slide are essentially a cliff notes, an answer to that question. But right there in brackets is something I have to reinforce. Do not feel compelled. Do not take it upon yourself to memorize the MOU. Right. And this is something that I learned in law school. Do not memorize, the criminal law case with the casebook. Don't do it. Don't memorize the civil code. The reason being, there's no need to. You'll get it wrong. You'll miss an element. Go back to the MOU instead of trying to, recall it from rote memory. Go back to the MOU and really read through the provisions that are being triggered by whatever the concern is. Don't put the pressure on yourself to memorize that entire document. When there is a dispute regarding the language of the MOU or the application of some aspect of the MOU, seek clarification from OCEA and your employer. Right? Sometimes it happens as a result of somebody's new in a role on the employer side. Sometimes somebody just mistakes. They make a mistake. They forget. These are humans at the wheel. These things happen. But our goal is to, again, address them quickly and get an efficient outcome so that we can all move on with our day-to-day lives and especially our working lives. If the terms of the MOU are misinterpreted or misapplied, employees have the contractual right to file a grievance. The grievance process, again, it is going to require time, attention, facts, details, grievance, and ultimately a reasonable remedy. But it is something with support of OCEA, we are more than happy to do because that contract matters and our ability to enforce it is a reflection of our strength as your union. And with that, I have gone through my entire PowerPoint.